Oh, okay, here we are. Do we make it? Do we make it? Do we make it to Monday? Hello, hello, welcome, welcome. Hello. Hello. Share Bear. Hello, everybody. I know this is a weird time, but for today, it's the only time that's going to work, unfortunately. So I am trying to still get rid of this cough here. Hello. Hi, Iceman. Don't be mean to Maverick, okay? Seriously. Hello. I am doing just fine. I've got a little bit of a cold that just won't quite go away, but other than that, we're doing all right. So never mind that. I apologize. Good afternoon, Kia. Welcome. My goodness, we got a lot of stuff going on. Yeah, there should be. Well, I'm not sure what fun. If fun's the right word, but sure. We could, we could hope. Oh, my goodness gracious. Oh, yes. I've got my fun nails in. These are little clouds. You probably can't tell, but these are like little clouds, and I just love that. Here, I will need to change them tonight, but enjoying today. I'm doing okay, AC. Thanks for asking. Regan, hello, welcome. He certainly is, Candy. He certainly is. I mean, that's a very good way of putting it. Oh, really? Oh, well, that's so sweet. I appreciate that. You come by anytime, all right? Anytime. I just need to get a schedule so people have some idea of when I'm going to go. Well, I'll have to work on that. Life goals right there, right? That's amazing to have that kind of an experience. I think that's wonderful. So, have enough water and coffee? I do. Okay, so I have my big cup here. This is my Monday mug. It's Garfield on here. You can't see it and I can't tip it because then things will go awry. But this is my Garfield mug. And then I have a whole bunch of cough drops over here. And I have a little throat spray, not sponsored, but I think we'll do okay. I think we'll be doing all right. Oh, that's so sweet. Well, and I've got to go. I'll be traveling the next few days, so I won't be able to come on. So I will have to get all of that sorted out. But welcome. So we are at the, excuse me, 3:30 here, Central Time. Hello, Laura. So we'll go ahead and get started. I hadn't planned to go live, but I tell you, there's so much going on in the Oregon. In California, Oregon, Illinois, we got some trouble, all right? Some big trouble here. So I thought, let's just go through it. I've not even annotated it yet, but I wanted to just look at the language, see how the court's coming after it, because this is the restraining order that she set out, right? And we'll kind of skip through that a little bit. But then, you live in Illinois. Yikes! Is it bunker time? Not quite yet. This is definitely going, when you have the thing where it's like, it goes all the way up and then the red part at the top and then there's a meltdown. We're a couple of slats up. But we're not there yet. In Chicago, yes. Oh, this is a mood ring, so this one changes color a lot, so it's kind of fun. All right, and so she had to issue a second restraining order yesterday. So she put a restraining order in on the 4th, and then last night had to do another one. So I thought, well, that's interesting. Excuse me. The only time I've seen that is when people were getting shipped out to El Salvador. So this is kind of a big whoop-de-doo-dah here. I know I had come on when the El Salvador situation had hit the fan in March, and I would say this is huge. This is a pretty enormous situation here where we have someone trying to federalize troops, and the governor, who's in charge of the state sovereignty and, enforcement of its own laws, is saying we don't need you here. So we're definitely in it. Portland. Oh, we love that. It's beautiful today. Oh, good. I'm so glad. So I thought, well, I'll read a few pages of this, and so that way that'll kick us into the second temporary restraining order that was needed. All right. So, and then of course we do have updates too. We've got I think a circuit judge. Her home had exploded. Whatever. We don't have any other information. We don't know if it was intentional or if, there were bad wires or whatever. But that did happen. So I think it's good to acknowledge that. Our judges are, not in a good place right now. And I'm not just talking about judges that have ruled against Mr. Orange. I think all of our judges, truly all of our judges right now are feeling pretty uncomfortable because of the situation. Because that's one of the first things you do, right? Before you take over, is you go in and topple the legal system. Okay, Judge Department. Oh, wait, so I can't read you. Here we go. Let me pull it back down again. Judge use of the Department of Defense instead of war. Well, and that's what's so interesting too, everyone. And this will be our little bonus moment. All of this Department of War crap was put out in a memo, and it was, was it a memo or an executive order? I can't remember. They all blend together. But it was something that Mr. Orange had set out, all right? And he had said, well, we can do the Department of War now. But if you read it, that's an executive order now that I'm thinking about it. If you read it carefully, like the president can't change the name. The name's been changed multiple times, don't get me wrong, but the president can't change it. Only Congress can change it. So what was written in the executive order is that it can't be put on any legal documents, anything that has any kind of historical bit. So if it's going to go into the archives, you can't use that, any of that. So basically what it was that, the Hegseth fella could use that as his title if he tells people that he wants to use that. So, how someone may have one name and then they're, going through life and finding themselves and they wish to be called another name. And so they're like, please call me this, not this. That's what the Department of War situation is, all right? So it's not like it's legally binding and in fact shouldn't be put on legal documents. But, apparently this fella wanted to have it as part of his Secretary of name. So only Congress can change that name, and that is not happening right now. Congress is unavailable. Congress is unavailable right now. Right. Only Congress. Yep. Like pronouns. Sure, absolutely. Very much like pronouns. Everybody. See the irony? Well, hello, Army Barbie. How you doing today? Things are getting crazy here. This is we're living in a mess, but that's all right. We'll clean it up. All right, let me grab my stickies so that I can write down. Let me see where they go. Sometimes I feel like I'm actually buried in a pile of sticky notes. I mean, that's how I'd like to go when I go, but it can be inconvenient. Oh, good. Oh, I'm so glad. Yay. Oh my gosh, I tell you what, sometimes after these lives with Amanda, I walk away and I'm like, what just happened? What was that? What? Is that the same for the Gulf of Mexico, America? Good question, Laura. And I have not read that executive order. I've not read it yet, and I should. Actually, I can write that down. Let me write that down here. Here we go. So, Gulf of Mexico. Yeah, because again, and that's true of a lot of his executive orders, everybody, is that the language, the first couple of paragraphs, I'll just, again, a little bit bigger bang for your buck this morning because I didn't give anyone any notice that I was coming on. But just to, let me make sure I got the right batch here. That's not the right batch. No, not that one. One more here. Okay, here we are. So when you look at his executive orders, everybody, they're only a couple pages, excuse me, except for one, which is like 69 pages. Good Lord, help us all. So what will happen in these executive orders, they're only a few pages long, right? So they're only a couple pages, which is what it's supposed to be. So the first few paragraphs, he basically, this is his rant for what he was saying during his rallies. All right, and it's just like polished up a little bit. So this part up here is like blah, blah, Biden, blah, blah, the whole world, blah, 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 blah. So you just kind of skip through that. The policy will tell you exactly what it is he's wanting to change, and then how he's going to go about changing is down here. So this part down here on how he's going to go about changing it has problems. There's a lot of problems in it. So because of that, when you start looking at this piece, it's kind of down here, start looking at it, you're like, well, that's not constitutional. So and that's exactly what happened with the Department of, War. Like he's writing down in here, well, sorry, but no, we can't actually do that. So kind of watch for that. The judge declined to stop the National Guard in Illinois. Yeah, Illinois is still filing right now. The docket for that case is still like every 30 seconds you refresh it and there's something different coming. So we will have a final knowledge of what's truly going on here in a little bit. I started by looking at Illinois, but I was like, no, that's moving too fast. All right. Okay, here we go. Over here. Oh, sure, of course. Excuse me. I am on the mend. All right, so I got that written down. I will go ahead and pull the Gulf of Mexico because that'll be interesting. Excuse me. I know it's so annoying to hear someone cough, but it will stop here in a couple of minutes. It's come with his own page of tinfoil. Oh, I wish tinfoil may be difficult, or aluminum foil may be difficult to find here pretty soon. Hello, Willie B. Yeah, it's an interesting time, Mittens. A very interesting time. Oh my gosh, the Portland protesters. Oh my gosh, Allison, yes. They're amazing. And I've seen crappy protests, and there's good and bad in everybody, in every group, in every state. But these people are like, goodness. And yeah, I'm saying these people, these peaceful protester peoples, they know what they're doing. Well, yeah, it's a little bit, I know. Was that contagious? I've taken all the tests. So just don't worry, everybody. I won't get you sick. All right, here we go. Let's go ahead and dive on in so we can read through this. I want to kind of hit the highlights. Sometimes I read verbatim for the whole case, but I'm not sure we need that. What I'm trying to do is get us a foundation built so we can jump into the second temporary restraining order that was just put into place like last night. All right, so here we go. Here's the case. We are in the District of Oregon here, so the city of Portland. Here's the case number for those of you who are wanting to pull this up online. Again, all of the court documents are all public information unless they've been sealed. And if they've been sealed, then, nobody knows what's in them. So that's going to be not available to anyone except for the direct parties involved in the case. Usually something will be sealed for the safety of someone or to kind of preserve the case if information gets out that could somehow negatively affect having a fair case. The judges will seal those. So here we go. We've got defendants here, the usual suspects. And we got a list of our names over here. All right, so this is this is from Judge Immergut, and I'm going to say the name wrong, and I apologize. I will say I'm sorry about 1,000,000 times because that's not right. I should know how to pronounce her name, but I just this district judge. So let's dive in. She's pretty amazing, in my humble opinion. This case involves the intersection of three of the most fundamental principles in our constitutional democracy. The first concerns the relationship between the federal government and the states. The second concerns the relationship between the United States Armed Forces and domestic law enforcement. The third concerns the proper role of the judicial branch in ensuring that the executive branch complies with the laws and limitations imposed by the legislative branch. Whether we choose to follow what the Constitution mandates with respect to these three relationships goes to the heart of what it means to live under the rule of law in the United States. So she came out swinging here, everybody. This is amazing, and she's absolutely right. And this addresses that question of, well, who's going to enforce it, right? Which we hear 5,000 times a day. Who's going to enforce it? And so she's like, look, this is where we're at. On June 7th of 2025, Mr. Orange issued a memorandum broadly authorizing the federalization of National Guard service members under 10 U.S. Code Section 12406 without specifying a designated location or duration. This memorandum authorized federalized troops to temporarily protect U.S. Immigration and Customs Enforcement and other federal employees who are performing federal functions, including the enforcement of federal law, and to protect federal property at locations where protests against these functions are occurring or are likely to occur based on current threat assessments and planned operations. And she is citing that declaration in here where that information came from. In the wake of this June 7th memorandum, protests ensued at the ICE facility in Portland. From June 11th to June 25th, these protests included violent behavior and required an increased law enforcement presence by both the Portland Police Bureau and federal law enforcement agencies. After June 25th, however, and we're in October, for anyone who can't remember, this morning I woke up and I'm like, oh, what month is it? The protests were generally peaceful in nature, with only sporadic incidents of violence and disruptive behavior. By late September, these protests typically involved 20 or fewer people. On September 27th, Mr. Orange posted a message on his Truth Social account stating that he was directing Hegseth, the Secretary of War, I mean, again, that's his preferred title, to provide troops to protect war-ravaged Portland from Antifa and other domestic terrorists, and authorizing full force if necessary. And then she's citing here. In response, on September 28th, Hegseth issued a memorandum authorizing the deployment and federalization of 200 of Oregon National Guard service members over the objection of Oregon's governor, Tina Kotek. That same day, the state of Oregon and the city of Portland, collectively the plaintiffs, brought this lawsuit against Mr. Orange and Secretary and Hegseth and Noam and the U.S. Department of Defense and Homeland Security, collectively the defendants. Plaintiffs allege that the defendants' actions were ultra-virus. Now, this is the new term that we should all know by now, right? This means outside of your power, so too much power. Now we'll go down here because she's got a footnote. Ultra-virus actions allow courts to adjudicate constitutional challenges to presidential acts and acts by subordinate executive branch officers that extend beyond delegated statutory authority. All right, so we're going to land beyond the authority that's been given when we're talking about ultra-virus, and therefore unlawful because they violate 10 U.S. Code Section 12406, the Posse Comitatus Act, which we've been talking about too. Posse Comitatus means local law enforcement, so where we're saying you can't come in and be law enforcement if we've got local law enforcement and they're taking care of it adequately. and 10 U.S. Code Section 175 by federalizing Oregon's National Guard. Plaintiffs also allege that defendants' conduct violates the 10th Amendment and the separation of powers doctrine by infringing on Oregon's state sovereignty and police powers. Finally, plaintiffs assert that Hagseth's memorandum violates the Administrative Procedure Act, so the APA. These, again, are all of the usual suspects for these lawsuits as well. We're seeing the same law being violated over and over and over again. Because it's not in accordance with the law, is in excess of statutory jurisdiction, authority, or limitations, and is arbitrary and capricious. Plaintiffs move. I know, John. John, I'm almost out of all my orange highlighters. All right. It's becoming an emergency. Plaintiffs move for a temporary restraining order, TRO, and stay of defendants' September 28th memorandum ordering the federalization and deployment of Oregon National Guard service members to Portland. Defendants respond that this court may not second guess the president's determination that conditions in Portland warranted a federal military response. So again, this is like the trifecta that is in every single case here, where the defendants are saying over and over and over again to the courts, the president basically has unlimited power, and so you have no jurisdiction. That's like in all the 400 is that right? Are we at 400? I don't know. No, 340. That sounds right. I got my 4 and my 3 mixed up. Hundreds of cases filed against the administration here. All right, so no second guessing. Defendants also contend that their conduct did not violate the U.S. Constitution or any statutory provision or exceed their statutory authority. This court has considered the briefing and declarations submitted in this case, the submission of amici or amicus curiae, which are other people chiming in with what they think is going on and how the law should work, and the presentation of the parties at the hearing on plaintiff's TRO on October 3rd. For the foregoing reasons, the court finds the plaintiffs have met their burden at this stage of the litigation and grants plaintiff's motion for a temporary restraining order. All right, so she granted it right here. Again, all of these preliminary decisions that are going on, like with TROs and preliminary injunctions, like we haven't even walked through the road of litigation. We just haven't even done that yet. We are way outside of actually getting full legal answers to the questions being raised in these complaints, because we're fighting so much about restraining orders and such, which is all pre 600 by the end? No, that can't be right. That can't be right. No, I don't believe it. I don't believe it. I don't want to believe it. All right, here we go. Now I'm going to fast forward here a little bit because we spend a lot of time going through the standards for preliminary and TROs. So I will just give you the test that needs to be used right here. So standards. In deciding to grant a motion for a TRO, courts look to substantially the same factors that apply to a court's decision on whether to issue a preliminary injunction. And then she's citing this case here. Quote, a plaintiff seeking a preliminary injunction must establish 1, that it's likely to succeed on the merits, 2, it's likely to suffer irreparable harm in the absence of preliminary relief. I was so busy thinking that this irreparable harm is one of the biggest issues out of this whole test that they've been fighting over. In absence of preliminary relief, 3, that the balance of equity tips in its favor, and 4, that an injunction is in the public interest. So again, this is our test to determine whether or not a temporary restraining order is okay. And this is a test that we use for preliminary injunctions. Also, the same one that the Supreme Court has set down when dealing with all of these questions that they've gotten so far. All right, here we go. Now, here's some of our background. Again, I'm not going to spend too much time on this because we do have kind of a pretty good idea of what the background is, but let's hit the first couple paragraphs here. So the National Guard, members of the National Guard must be activated to serve on a mission. Declaration of Lieutenant General Jeffrey S. Buchanan, retired. So the declarations, if anyone's interested in I know you can't hear me when I'm rumbling my stuff, but for anyone who is interested, you can go online yourself and you can pull this declaration up and read it. And you can also say, like, I don't think that's what it says, or I do, or whatever. But these citations are to registered exhibits that are on the docket. First, they may serve in state active duty in the state where they are commissioned when the governor of the state or commonwealth activates their unit and they are under the command of the governor. Second, they may be activated under Title 32 of the United States Code, where the governor asks the federal government to bring troops into active duty for a particular mission, and they are under the command of the governor, but the costs are borne by the federal government. And then this is 32 U.S. Code, Section 502 sub F, sub 2 sub A. Finally, they may be activated under Title 10 of the United States Code, where they are considered federal military and under the command of the U.S. President, the Federalized National Guard, and that's put into Buchanan's Declaration. This is the activation that occurred here. State active duty National Guard troops, those activated under Title 32, may engage in domestic law enforcement functions, subject to restrictions under state law. Federalized National Guard troops activated under Title 10 may not engage in domestic law enforcement activities, with some exceptions. Members of the National Guard generally do not receive training to perform local law enforcement tasks, such as learning de-escalation techniques, the use of non-lethal force, or how to properly conduct criminal investigations. And these are all so important because they are different pieces of the Constitution for law enforcement. Law enforcement resources in Portland. Again, just a couple paragraphs here. Plaintiffs present several witness declarations from law enforcement officials, local law enforcement officials, detailing local and state law enforcement resources that stand ready to address unlawful conduct at protests in Portland. The primary local law enforcement agency is In Portland is the Portland Police Bureau. PPB employs approximately 812 officers. And all PPB officers are trained in crowd management and the First Amendment. Well, that's so important. Crowd management incidents commanders receive an additional 40 hours of crowd management training. PPB also has a rapid response team of 50 officers that is specially trained in crowd management intervention, removing someone from a protest, and direct crowd control through approved maneuvers and tactics. Like, that sounds pretty good. That sounds like they've got some training. That's all right. The rapid response team receives an initial 40 hours, right? Of crowd control training, 10 hours of crowd control training per month, meeting the standards of the National Tactical Officers Association. I don't know what's going to happen to that. All associations are, all on the table. The rapid response team works under a crowd management incident commander. There's a commander for crowd control in Portland, everybody. Goodness gracious. Move the paper down. Oh, absolutely. I have like 2 screens that I'm working off of, and they have me set to different levels here. So if I'm just looking at one screen, I may not notice that it's too high or low on the other. So I'm glad you told me. All right, so back into it. We were saying Portland's got somebody that does just that. The rapid response team works under a crowd management incident commander, and PPB also has specially trained dialogue officers who work with protest organizers and mobile field forces who can move from one precinct to another as the situation demands. So again, yeah, Atticus is always his fault. So something that I think is really important to note, right? They've got this whole protocol set out for crowd control, right? For protesting. They have it. They've got people designated leaders. They've got training, all of that. And the big thing with the National Guard is that if pulling them in, federalizing them and pulling them in, is because local law enforcement can no longer do it. So by setting out all of these different resources, what, Oregon's been saying is like, we got this covered. We don't need you here because of that. And again, that just supports this piece saying you are, that level of exercising of your authority is too far. You're going too far. All right, so we're going to kind of fast forward again here. They're going into, all right, so we're going to kind of fast forward again here. They're going into that. All right. Hello, Johnny. Welcome. Okay, so here we go. Next piece, protests in Portland. So let's get our intro paragraphs here. All right, so let's start here. We got to call them the cubes with our TikTok language. Protests in Portland. The Cubes have a facility located at 4310 South Macadam Avenue in Southwest Portland. This is according, again, she's citing her source. This facility encompasses approximately 1 block of the city of Portland. Following federal officers' arrest of asylum seekers in Portland's immigration court in June of 2025, protests broke out around the Cubes facility. These protests were small, generally involving fewer than 100 people, but were concentrated on the Cubes facility and disruptive to the facility. The Cube facility is within PPB's central precinct. Unless a crowd management incident commander is activated, protests at the Cubes facility are monitored by central precinct. Assistant Chief Dobson activated a crowd management incident commander for the ICE facility protests from June 11th to the 25th. The protests were mostly peaceful, but there were some individuals who engaged in unlawful conduct requiring PPB intervention. PPB made 25 arrests from June 11th through the 19th. After June 25th, they transitioned monitoring over to the Central Precinct because the PPB determined that protests were low risk. Since July 18th, the PPB has carried out routine monitoring of the ICE facility protests without serious incident, and the risk posed by nightly Cubes facility protests have not merited anything more than standard periodic monitoring like any other neighborhood in the city. So again, we have people trained where it's their job. This is their job to make sure everybody's all right. And they're like, well, we've got low risk here. Super low risk. Hello, Olga. Yep. So there's that. And again, they're showing here, if you want to call in and federalize the National Guard, you need to say local law enforcement can't do their job. That's why they're needed. So let's do one example here. They've got several examples of how they're going about it, but we'll go ahead and hit the June 24th example here. All right, so here's an example. On June 24th of 2025, one protester was detained for assaulting a federal officer with a machete and knife. The officer deployed his taser and recovered the protester's weapons without getting injured. All right, so if you're bringing in a machete, all right, I am absolutely in support of whomever with the authority removing that. All right, let's just be clear here. You shouldn't be bringing your machete to a protest. That's not right at all, okay? Another protester, SHOT officers with a paintball, GUN, also not appropriate, also needs to be prosecuted. This is not okay to do that. And a third shined a laser in officers' eyes. Ooh, the laser, that's no good either. These are all pretty significant incidents. All three were arrested by federal law enforcement and charged with assault of a federal officer. Another protester attempted to set a U.S. flag on fire in the driveway. Now, if you want to set fire to a U.S. flag, legally, as of this moment, you certainly can't. That's not legal advice. But you need to watch the location. Where are you doing that? Is it in your barbecue? Or is it in some other place where it's not really zoned for you to be setting stuff on fire, right? Leave the toys at home. Absolutely. Absolutely. And I really, really want to make sure to emphasize this because I know so many of us feel the same. Like you're bringing lasers and paintball stuff in. That is not okay. So I don't care who you are. That's not all right to do that. On June 29th, the protester tampered with the card reader at the Cube's facility and resisted arrest. Again, charge them, get them in. Ultimately, 3 card readers were damaged in June of 2025, as well as damage to gates and windows. Again, that is not okay. People need to be charged and they need to pay for the damage. With the card readers broken, personnel must call someone ahead of time to let them in, causing delays and inconvenience. And again, that's destruction of someone else's property is not okay. That is illegal. The Cube facility, and again, that's destruction of someone else's property is not okay. That is illegal. The Cube facility in Port. Man, I'm getting calls left and right here today. All right, sorry about that. So, July 7th, damage. As a result of the closure, most Portland Cube officers had to work out of a separate temporary space. And that could definitely be a hassle. Would it really be illegal to take leaf blowers to blow back the chemicals? That's a good question, and I'm not sure. I'm really not sure because, and I say that because, what harm is a leaf blower doing, right? So because we've got property here that's being jacked up, you can't be shining lasers in people's eyes. Come on, people. Destruction of property, right? But if you've got a leaf blower, I mean, what's the contact that's making an assault? You know what I mean? So I'm just not sure. Really, I looked it up. You can't legally return pepper, pew-pews, or stink bombs. You can't return them. You can't send them back. So like if it falls in front of you, you can't pick it up and throw it like in the movies. Well, I think that's probably right that you can't. But, I mean, you don't have to throw it at them. You can throw it somewhere else, right? Throw it, right. I've seen them used in protests before, yeah. Mm-hmm. Can you turn in with a stamp? That's funny. All right, I don't want to laugh too much. I'll start coughing. All right, here we go. So we do have, again, those are a few examples. We do have a legitimate issue, a legitimate question here that we're talking about. There are people that were doing a lot of damage for sure. And there was safety issues going on, interference with the federal building and their ability to do their jobs. All of those things are illegal. You're not going to be protected by the First Amendment when you're doing that kind of damage. It's just, or assaulting. It's just, you're just not. It has to be peaceful. Right. So you gotta, yeah. So I'm just telling you that so that you know I have no sympathy for these people who are breaking the laws in this situation. All right. So next up, so then defendants' actions relating to federalization on National Guard. So let's take a look here and see what the federal government is doing regarding that. I gotta take a, oopsies. There we go. I have to get some coffee. I need an IV, everybody. I need a coffee IV. All right, on June 6th and 7th. Keep in mind, though, one other thing, too, to remember. Those were things done in June. Everything got shut down for like 30 days or a few weeks. So there has been a bit of time that has passed, all right? On June 6th and 7th, 2025, violent protests broke out in Los Angeles at Cube facilities and elsewhere. On June 7th, Mr. Orange issued a memorandum to the Secretary of Defense The Attorney General and Secretary of Homeland Security broadly authorizing the federalization of National Guard service members under 10 U.S. Code Section 12406. The June 7th, 2025 presidential memo recited that, quote, incidents of violence and disorder have recently occurred and threaten to continue in response to the enforcement of federal law. Excuse me, and other United States government personnel who are performing federal functions and supporting the faithful execution of federal immigration laws. All right. The presidential memo also stated that the protests threaten the security of ICE detention centers and other federal property. The June 7th presidential memo concluded that to the extent that protests or acts of violence directly inhibit the execution of the laws, they constitute a form of rebellion against the authority of the government of the United States. So this is the memo, all right? So this is what he wrote in the memo. And this leads me to a question that I've really been chewing on the last 48 hours. When we're talking about this, I have a fly in here. I blame Atticus. Atticus, get the fly. When we're talking about sending in, federalizing National Guard so they can go in to federal properties and protect federal employees so they can do their job. Here's my question. Why aren't they protecting federal judges? That's my question. Like you're like, oh, well, they're keeping it so that we can't do our job. Meanwhile, our federal judges are in incredibly questionable situations here, and no one's been sending in any kind of, National Reserve people to help them. You see what I'm saying? Like this isn't something that like, oh, this is so important that we've just got to, get it right off the bat. You got to get it because we are having a lot of problems with our federal prosecutors, with our federal judges. So where is the protection is what I would put in there. Yeah, right. Meeting post-its. Only protecting federal property, it seems. Yes, right. So I think that's a really good question to ask. And then also, because it's a two for everyone. So we ask, why aren't they protecting, the prosecutors or the judges, right? The federal ones. And then the next question is that what the National Guard is supposed to be doing? Is that their job, right? So if their job is not to protect judges, then they can't come in and say, our job is to protect federal employees and make it so they can do their work. See what I'm saying? They're going to get kind of stuck here. But if it is their job to protect our judges, like bodyguard style or whatever, if that is their job, then this makes what they're doing easier to follow. Right. Well, again, who's in charge of the federal National Guard? Once our National Guard gets federalized, who's in charge of that? That's a good question. Anyway, just that's a point to ponder out there that I've been wondering about, because it seems like it's very specific who's being helped here. Who's being helped? Only those specific employees that are working in the immigration situation rather than anyone else. So, all right, here we go, back in it. The June 7th presidential memo authorized the federalized troops to temporarily protect cubes and other U.S. government personnel who are performing federal functions, including enforcement of federal law, and to protect federal property at locations where protests against these functions are occurring or are likely to occur based on current threat assessments and planned operations. Again, just really shining a light on this idea that, federal judges are doing their jobs too. Federal prosecutors, federal defense attorneys, they're all doing their jobs and without any help, right? So the number of National Guard troops was to be no fewer than 2,000, and the duration of deployment under the June 7th presidential memo was 60 days, or at the discretion of the Defense Secretary. The June 7th presidential memo did not refer to any specific location. Really? Okay, that's interesting. That's very interesting. In response to the June 7th memo, that same night, Secretary Hegseth issued his own memorandum federalizing 2,000 California National Guard members. 2 days later, he federalized another 2,000 California National Guards members and deployed the National Guard along with approximately 700 active duty Marines. So I'm going to pause here for a minute to also remind everybody that, this fella who is just no appropriate training to do what he's doing. Just imagine you're like chit-chatting with some, dweebers over on the news and making sure your makeup's right and your hair is stuck in place correctly. And then a few months later, you're calling up active duty Marines, right? So you can see how that might go to his head a little bit, and it might make it so he's not making necessarily the best decisions, right? So that's something else to kind of take into consideration. And that is, of course, the same situation by calling in all of the head people of the military into an auditorium to tell them, how you're feeling. See what I'm saying? A dolphin. You're so funny. All right, so we're pulling in more troops. The first of these troops arrived in Los Angeles June 8th. Governor Gavin Newsom and the state of California and Mr. Orange and other defendants obtaining a TRO under Section 12406, which was stayed by the Ninth Circuit. On September 19th, Mr. Orange explained that the administration was going to get rid of the problems in the cities, including Chicago, Memphis, Portland. According to this declaration, he described that in Portland, people were out of control and crazy. They were doing the electric slide, everybody. I can tell you that much. On September 25th, the president again described Portland, exclaiming that nobody's ever seen anything like it. Well, in the 80s and 90s, the electric slide was very popular, with actively happening every night with people that just burned the place down. Mr. Orange commented on professional agitators in Portland who are paid a lot of money by rich people. What? Anarchists and crazy people who try to burn down buildings, including federal buildings, with Portland having activity every night for years. What does that even mean? He promised to do a pretty big number on the people in Portland that they are doing that. I wish I was paid. I know, right? I'm like, where do you apply for that? Like, do you fill out a form, or is it just like if you know somebody? Like, I want to be a professional protester that gets tear gassed and assaulted and harmed, run over, smashed into stuff and thrown away, and potentially go to jail. And I'm going to do that so I can get paid, right? Right. Sorry, everybody. Oh my gosh, my coffee today is so good. It just really is. The Harry Potter Peppermint Toad Creamer. It sounds amazing. It's not, but it sounds amazing. You can give it a try, but then you're going to have to add some stuff to make it drinkable. All right. Right. He was describing the cubes. Exactly. Okay, so here we go. And again, we're about halfway through here, and I will be skipping up just a little bit because I do want to get into that second restraining order that she's put out. All right, so on September 27th, Mr. Orange posted a message on Truth Social stating, at the request of Secretary of Homeland Security, Kristi Noem, I'm directing Secretary of War, Pete Hegseth, to provide all necessary troops to protect war-ravaged Portland and any of our cube facilities under siege from attack by Antifa and other domestic terrorists. I am also authorizing full force if necessary. What the H does that mean? I think we all know what it means, but I'm not sure he does. Thank you for your attention to this matter. Right, right, right. I mean, can you? Yeah, I know. Peppermint toad. I know it's weird, Liz. Can you even? All right. What's the prediction of what's going to happen if one of these cubes, right, with the protection of the National Guard, unalives multiple people, right? I mean, we're already kind of seeing some of what's going on there, but they're not trained in a way that makes it so that this doesn't affect them in any way, right? And what you see when people are getting thrown around and hit or shoved into cars or screamed at by the cubes, it's because they're on their last straw, right? I mean, you just escalate until you can't stand it, and then you get violent. And I have no doubt that we're going to hit that point, and the violence, rather than being shoved around or whatever, is going to be lethal. And that is very stressful. Oh my gosh, Kent State 2.0. Yes, exactly. We've been talking, well, in my world, a lot of us have been discussing that very thing. Exactly right. Yeah. I can't imagine. Well, I know. I feel bad for the National Guard too, right? I mean, come on. Yes, I do too. Now, again, when it comes to, obeying orders and such, all of that's important, and it's, critical. You have to do that. But your oath to the Constitution is higher than that order received. And our military knows that. They do know that. So they don't need someone to scream at them from a stage. They already know what's going on there. All right, so let's fast forward here. So there's no insurrection. We know that. They have plenty of safety in place. They have a whole group that does just crowd control. So they're like, we are set. We don't need any more soldiers here. So, I do too. I hope they stay safe. Definitely see that coming. Oh my gosh. Yeah, Jennifer. Oh my goodness. I know. Yeah. Stuff's got to back down. This has got to de-escalate, or we're going to be seeing some fruit fly in here pretty soon. All right. October 1st, President Trump. Mr. Orange posted on Truth Social. Again, I use that name so my algorithm doesn't get dinged all over the place. As I determined on September 27th, when I activated and called into service the National Guard in Oregon, conditions continue to deteriorate into lawless mayhem. Our great federal law enforcement officers have not been able to enforce the laws in Oregon. Antifa and the radical left anarchists have been viciously attacking our federal law enforcement officers, men and women, who are simply doing their jobs, protecting federal property and enforcing federal immigration laws and the rule of law. We will never allow mobs to take over our streets, burn our cities, or destroy America. The National Guard is now in place and has been dedicated to restoring law and order and ending the chaos, unalive, and destruction. We are a nation of law, and we will prevail. Thank you for your attention to this matter. So, another thing to kind of think about as we go through this here, right? So they're saying viciously attacking, right? And we've got a mob trying to take over streets. So these two phrases, I'm just going to use these as an example. These are kind of like a legal, they have a legal meaning behind them, right? So legal definitions. You can say what you want to say in a tweet or a whatever, but when it comes down to it, we have legal definitions of what these are. What does exactly attacking mean? What does a mob mean? And if he doesn't really know, which he probably doesn't, most don't, I would refer him to the second set of impeachment articles, because they actually found that we had some attacking and mob behavior on January 6th. And so that might be helpful for him to understand that, this has been decided legally as a mob, and actually a couple of other situations. But this, on the other hand, what's happening in Portland, not so much. Not so much. Oh, I missed it. I missed the pin. Sorry about that. Protesters stand around. Take some bananas. Make sure you're hydrated. Okay, well, we'll keep moving forward here. But I think this, again, is important. If he's saying we're in a war zone, like, okay. But if we compare, like, put the videos next to each other, January 6th, Portland, and see, because January 6th, again, has already been designated. Do you ever explain case briefs? Oh, sure, absolutely. I do have my my DMs open. Sorry, I gotta get another cough drop. I have my DMs open, and if there's a case that you're interested in, or how to even brief it, you can just leave a case for me, and I'll take a look at it. I've always be happy to help out with that. Cities declared, really? Can I apply for asylum elsewhere? Good question. Well, and you have to wonder too, like, does that mean, are like rations gonna be put back into place again? Like what's going on here? You're using big words. Like, do you have support for those big words? And the answer to that is no. He may be using some of the Jan 6 people as, oh, absolutely. What defines a war zone? Well, that's a great question. And I would say go international for that. I'm not sure just U.S. code's going to be the best. I would say go international. Bread lines. Oh, my goodness. Right. Ugh. All right. We're teetering, people, but we're still okay. We're still okay. So let's go forward here from this. And she's setting out again what they are alleging that he's violating here. And he's already been found in violation of the posse comitatus. Likelihood of success on the merits. So what she's doing, and she's going through each of those factors and seeing whether or not they are being met in order to have this temporary restraining order, right? So let's get the highlight here. Whether Mr. Orange is unable with the regular forces to execute the laws of the United States. That's very important too. So let's dive in here to sub B. Defendants first argue that the president had a colorable basis for invoking 124063 because he was unable with regular forces to execute laws of the United States, which again is the only way you can come in and do what he's doing, as if all other options are not available. Although Section 124063 does not have a prerequisite that the president be completely precluded from executing the relevant laws of the United States, quote, minimal interference with the execution of laws is by itself insufficient to justify invoking 124063. So this is really important. This is what all of these cases are going to come down to. He is saying that local law enforcement, or posse comitatus, local law enforcement can't handle it, so I have to step in as the federal government. As a threshold matter, the court must determine to what extent the president can rely on violence that occurred months prior to his September 27th federalization directive and that had subsided by September. Under Newsom 2, and as a matter of logic, this court assesses whether Mr. Orange invoked Section 124063 based on a colorable assessment of the facts as they existed at the time he federalized the National Guard. So she's getting this set up here. In Newsom 2, the Ninth Circuit evaluated the protesters' interference with the ability of federal officers to execute the laws leading up to the Mr. Orange's federalization of the National Guard on June 7th. And the Ninth Circuit specifically cited events from the day before the June 7th federalization order to conclude that Mr. Orange had a colorable basis for invoking 124063. Likewise, this court will focus on the ability of federal officers to execute laws leading up to Mr. Orange's federalization of the National Guard on September 26th. In this case, and unlike Newsom 2, plaintiffs provide substantial evidence that the protests at the Portland Cube facility were not significantly violent or disruptive in the days or even weeks leading up to the president's directive on September 27th. The record evidence establishes that while disruption outside the facility peaked in June of 2025, federal and local law enforcement officers were able to quell the disorder. Here, citing Newsom, as of September 27th, it had been months since there was any sustained level of violent or disruptive protest activity in Portland. During this time frame, there were sporadic events requiring either PPB monitoring or federal law enforcement intervention. But overall, the protests were small and uneventful. So again, that's huge. Defendants' declarants describe only 4 incidents of protesters clashing with federal officers in the month of September, preceding the federalization order, September 1st, without further specification. The second week in September, the first involved protesters setting up a makeshift guillotine. Like, it's like we're creating all kinds of like musical theater out there with people. They're just constructing a guillotine. You know how it goes. To intimidate federal officers. The second involved 4 people shining overpowered flashlights in the eyes of drivers. That's not cool, people. The third involved someone posting a photograph of an unmarked cube vehicle online. And the last involved additional drivers having flashlights shown in their eyes. You gotta be careful with the flashlights, people. Right? You gotta be careful with that. Because, these incidents are inexcusable, but they are nowhere near the type of incidents that cannot be handled by regular law enforcement forces. Like, they can't go get the flashlights? I mean, come on. They also occurred at least 2 weeks before Mr. Orange issued his directive. More broadly, these incidents are categorically different from the violent incidents as described in Newsom 2 that took place in Los Angeles when the president federalized the California National Guard on June 7th. And the examples there, protesters threw objects at cube vehicles trying to complete a law enforcement operation. They were pinned down, several FPS officers defending federal property by throwing concrete chunks, bottles of liquid, and other objects, and used large rolling commercial dumpsters as a battering ram in an attempt to breach the parking garage of a federal building. So let me ask you this. If you are looking to purchase somebody's actions, this could be the best place if you wanted to do that. If I wanted to be a violent protester, I would, of course, be hired by probably by the feds, because then, they could give me a pardon if things got out of control. You know what I'm saying? It would be much safer to be a paid protester or agitator to the federal government as opposed to the other side. Yeah, our reality is hired agitators, right? And you can do that. I mean, I'm just putting that out there, points to ponder here. All right, so let's fast forward again. Okay. And we're going into the forces that are allowed and which ones aren't. Okay, and then sub C, whether there's a rebellion or danger of rebellion. So let's hit a couple of these paragraphs. Hello, Betharu, good to see you. Defendants also argue the September 28th federalization order is authorized under Section 2, which permits federalization of the National Guard in response to a rebellion or danger of a rebellion against the authority of the government of the United States. In the June 7th memo, Mr. Orange stated that to the extent the protests or acts of violence directly inhibit the execution of the laws, they constitute a form of rebellion. The parties disagree about the meaning of the word rebellion in the statute. Interpretation of a word or phrase depends upon reading the whole statutory text, considering the purpose and context of the statute, and consulting any precedents and authorities that inform the analysis. Additionally, courts must interpret words in statutes consistent with their ordinary meaning at the time Congress enacted the statute. The Ninth Circuit did not reach the government's rebellion arguments in Newsom 2. In Newsom 1, however, the district court performed a detailed statutory interpretation of 124062 that this court finds instructive. There, the court surveyed 4 dictionaries from the late 1800s to early 1900s, when Congress passed the first predecessor statute of 12406, the Militia Act of 1903. And we're going to fast forward. All right. So we've got that information. Fast forward here. 10th Amendment here, where she's setting out, the difference between state versus federal rights, of course. Irreparable harm, another factor for that temporary restraining order. Balancing the equities and public interest. That's the last piece to the test. So here we go. Here's our last paragraph and conclusion. We can hop over to the other restraining order that she did just yesterday. So this one was set out on the 4th here, for those who are curious. Hello, can we see? Okay, everyone, let's do a page check here. Am I in the boundaries? Okay. Hi, Nancy. Frog is my favorite. Oh, VC, they went after him. Okay. Think about Cam. Oh, thank you, Tiffany. Oh my gosh, you're so sweet. Such an amazing artist too. About Cam. Yeah, we don't know about that. Okay, it's looking good. Okay, here we go. Let's dive in then, everybody. All right. Furthermore, this country has a long-standing and foundational tradition of resistance to government overreach, especially in the form of military intrusion into civil affairs. That tradition has deep roots in our history and found early expression, for example, in the constitutional provisions for civilians' control of the military. Also see James Madison's address to the Constitutional Convention of 1787, reprinted in the records of the Federal Convention of 1787. See, that's how far we got to go back to get these things sorted out. A standing military force with an overgrown executive will not long be safe companions to liberty. The means of defense against foreign danger have been always the instruments of tyranny at home. This historical tradition boils down to a simple proposition. This is a nation of constitutional law, not martial law. Defendants have made a range of arguments that, if accepted, risk blurring the line between civil and military federal power to the detriment of this nation. Whoo, that's powerful. That's very powerful. All right, so here's her conclusion. For the above reasons, the court grants plaintiff's motion for temporary restraining order and temporarily enjoins defendants from the 28th memorandum ordering the federalization and deployment of Oregon National Guard service members to Portland. The TRO expires in 14 days. On October 18th, the parties are ordered to comply with the attached TRO. The defendant's request to stay or administratively stay the temporary restraining order here is denied. Denied. It's so ordered. Again, so that was on October 4th. Right. Okay, so, all right, and then here she's just set out the temporary restraining order factors. So that was her original order that came in here. And then, as many of us have probably heard, they tried an alternative route where they decided to try to get California National Guard to come into Oregon. Because here, she's only talking about federalizing Oregon National Guard, right? So then there's the question, right? So that's why he's trying to rile. Oh, absolutely. This is all part of the plan. But, the American people are not, that's not cool. We're not like, hey, that's great, do that. No. All right, so yesterday, everybody, they had to meet, have another situation, because that's how it is right now. They're trying to be sneaky, little slimy people to do that. So second temporary restraining order. Based on this court's prior opinion and order granting plaintiff's first motion for temporary order, which we just went through, the hearings on plaintiff's second motion for temporary restraining order, and the newly submitted declarations, this court grants plaintiff's second motion for a temporary restraining order and orders as follows. 1. Defendants are temporarily enjoined from deploying federalized members of the National Guard in Oregon. 2. The second temporary restraining order expires by its own terms in 14 days. So this is 2 weeks. This is just 2 weeks, so they can get the case up and running in courts. Plaintiffs are ordered to post a nominal bond of $100. Within 48 hours. The bond shall be filed in the clerk's office and be deposited into the registry of the court. Defendants request to stay or administratively stay the second temporary restraining order, which was raised in the hearing on plaintiff's second motion for temporary restraining order, is denied. I'm going to pause here. So we got that first restraining order, right? And so then they're like, well, we need a second restraining order because they're trying to pull him from California. So they have a hearing. And the defendants are like, well, if you're going to do a second restraining order, can you just stay it, though? Because we're going to appeal. Like, why would you even do a restraining order if you're just going to, pause it? Like, that's ridiculous. Oh, my goodness gracious. All right, number 5, the court clerk will contact the parties to schedule a telephone hearing on October 17th to address whether the second temporary restraining order should be extended for another 14 days. Now, this is not an injunction here. This is just a restraining order in order to keep troops from other states coming into Oregon. All right, so we got to kind of walk that fine line there. Can Chicago do the same? Absolutely. And Illinois has filed. Right now they are still filing. I mean, the filings were happening like every 30 minutes. So when I sat down to start this live, there'll probably be multiple other things filed. But yeah, of course they can. Go for it. All right, extended. Any motion for a preliminary injunction shall be filed no later than October 17th. Defendant's opposition shall be due no later than October 23rd. Plaintiff's reply, October 27th. A combined hearing on the preliminary injunction motion and a trial on the merits under Rule 65A2 is set for October 29th before the Honorable Judge Karen J. Immergut in courtroom 13A beginning at 9 a.m. So ordered this 5th day of October. All right, so this was the second restraining order. And, we've had some problems with restraining orders. That's why the birthright citizenship went up in front of SCOTUS and they just decided temporary restraining order stuff. All right. So, and also why everyone needs to file class actions, except in this case, it is, again, to the detriment of the specific state of Oregon. All right. So that's the Oregon case. The Illinois filings, I'm hoping, will probably be finished by 5 today, and then it would be easier to pull what the final filing is and go over that. But yeah, we're in some trouble here in River City, but it's not unfixable. I guess I put it. I like my presidents to not need restraining orders. Same. Same, but as you'll note, in all of his cases, they had to put extrajudicial comments or speech. They had to be quiet. Restraining orders were required because we had so many problems. So unnecessary, Chicago, right. Well, I'm not sure. I mean, Chicago and Illinois, I mean, they're not playing around. This is what's happening right now with the pulling everybody out of the apartments and just going in is just so awful. It's so awful. It reminds me quite a bit of Korematsu, which was one of the worst cases ever decided by the U.S. Supreme Court, where Japanese Americans or Americans with Japanese heritage were kind of just rounded up and put into tents and camps. Now, some people a couple months ago were like, oh, everything's crazy. You're talking about the camps again. That's just, fear mongering. This is what they are doing right here. This is what they're doing. Now, they're not going into tents, camps yet, but they did a trial run setting up a tent in Florida, which got knocked down by the court. But we have to proceed with extreme caution here because we have a part of the government that thinks they can just do anything. So there's going to be a lot of pushback. There are so many people, though, working on this, being like, you can't do this. This is some bullshittery, including the judges. The judges aren't playing around either. So, we're in for a good fight. So, make sure to get your stuff ready. Do we ever figure out where they took the people that were in Florida? Yes, Lisa. Yeah, it looks like they were just moved to other detention facilities. You think the political question doctrine will be invoked by any courts in these cases? It's always possible. The political question is one of the biggest ways to get a case knocked out, right? Because you're not supposed to answer any political questions. Answer questions of the law, not of politics. Policy and politics, that's not supposed to be under the purview of the courts. But the defense always raises it. Political question is like number 3. First, they say courts don't have jurisdiction over the president's actions first. Next, they'll say, well, it's it's foreign affairs or military, right? And so we've got complete and total control. And then third, they're like, we don't have standing anyway because this is a political question. So that's always like at the top of the list. So the question of, is this a political question regarding bringing in National Guard and federalizing them? I think it's one of our weaker political question situations. That's going to be really hard to win on. They're still going to plead it, I have no doubt, but it would be very difficult to win on a political question. Yeah, they're trying to pick a fight. Yeah, absolutely. Right. I mean, they really are. And that's kind of their MO, right? Their modus operandi. They just are, the administration will go in and they'll say, we want this area to look like this. And if you don't fit what we want in this area of a state, we're going to figure out a way to get rid of you. And which is just awful, right? Because they're federal government, like the state sovereignty is like kind of a thing, that's a big thing. So they're coming in trying to take over the states. You're welcome, of course. It's a great question, Dee. I think you're gonna see it asked multiple times. I think SCOTUS will rule on the National Guard issue. I do not know. At this point, I do not know. Let me get my real quick, because they just started today. So what day would be appropriate to get the pictures out here? Let's see. Oh, here we go. There they are. This is easier than getting the puppets out. So for those of you that prefer the puppet, Supreme Court, apologies. We'll just have to look at the picture. The problem here, and in trying to figure out what's going to happen, is that, although conservative, this court is incredibly conservative. It's not conservative or nothing, right? So Thomas and Alito are the most conservative justices on the bench. So we've got 2 for sure conservatives. Sotomayor and Jackson are for sure not conservative, so liberal. For sure. So we've got ties, 2 and 2. Justice Kagan is definitely liberal, except she can flip to the other side depending on the issues. So there have been a few times where she has gone and sided with the conservatives, all right? And so she's mostly, though, on the side of the liberals. And then we've got Gorsuch, who thinks that he's like Louis XIV. Like, he deigns to like float in from the heavens and sit during oral arguments and like nods his head with his scepter, it's like, oh, this is, it's okay, forever. But he's a flipper. We don't know exactly. He tends to flip conservative. So don't get me wrong, he flips conservative, but there are some issues, again, where he will be backing up the liberal justices several times. So there's that. And then we've got Kavanaugh, who's just like, you know, a battering ram. Like there's no elegance to his conservatism. He just smashes everything. He's like, you know, get out of my way, get out of my way. I said what I said, now I'm gotta go. So he is conservative as well, although every once in a while he'll get snagged up on something and is like, no, we can't do that. And then Justice Barrett, she's a flipper. She's starting to flip a little bit more conservative, and I think she's I don't know. I had high hopes for her. I still do. She's an incredible writer, professor for a long, long time. So I think she's still got potential here, but she's a flipper. And then Justice Roberts is a flipper. So we basically have two huge flippers. So we don't know where they're going to go. Two conservatives, two liberals, and then two right-leaning flippers, and then one left-leaning flipper. All right. So as I try to explain the breakdown of the court, it's not just easy. It's not, you can't just say, well, you know, it's a conservative court. Because, you know, Justice Sotomayor will come and take care of business if you say that. She's like, no, it's not. I mean, she's there. All the people are here. We've got ultimately two justices who've had articles of impeachment requested, and just these two. And the rest of them, do I like how Gorsuch is going through? Absolutely not. Is he going to step in line with Alito? More times than he will with anyone else, but not every time. So we just don't know. We just don't know how it's going to go. We just don't know at this point. I just, you know, and I know a lot of people are so upset with the Supreme Court, as I am as well, because some decisions have come down here that have been complete rubbish. You know, with regards to like the Chevron doctrine, we've got all kinds of stuff. I think we've got another one that's probably going to get overruled. Another huge precedent is probably going to get overruled. But there are other cases where they come in and they are unanimous. Not very many, but unanimous. Or it's kind of an odd mix. And if you look to see who voted for what and why, you're like, what? I mean, there have been cases where, you know, Gorsuch will join the liberals, or cases where Kagan will join the conservatives. So it's not always a guaranteed. It is case by case, truly. Hold on here. I've got it. I think it's, what's it called? Like Humphrey's Executive or Executor is the one that we've been talking about. Let me see. I've got it here on my list. It's in my to read and annotate list. Yeah, so that's it. Humphrey's Executor. And that has to do with hiring and firing. So that's a kind of another federal employee case, because we've got a lot of those going on. Oh, I know. I miss her too. Yes, thank you, Thomas. That's right. Yeah, Humphrey's Executor. Thank you. Yep, appreciate it. Stats are not in our favor. I agree. I can't sugarcoat it here, everyone. I agree. We are definitely not in a place where we can be comfortable with what's going to happen. It's going to be a tough session. It's going to be tough. And they just started today. Just as heads up, we have two writs of cert that were denied. The Maxwell one and, oh my gosh, who's the other one? The Laura Loomer, I think her name is. I think her cert was denied too. Legal Dad's done a great post on both of those. So if you pop over to Legal Dad here on TikTok, he's just got a couple of posts that are just wonderful explanations. So that's happened just today. So it is incredibly disappointing. It really is. It's heartbreaking. When does the session end? They try to end it before the 4th of July. She is insufferable. And I still have her deposition to read. So we'll keep going with that. Oh my goodness. All right. Well, with that, my friends, I will go ahead and say fare thee well for today. I've got a lot of stuff going on in the next few days. I'm flying to Chicago. Wish me luck with that. Yikes, because TSA is like, we're not paying anybody, and Chicago's like, what's happening? So it's going to be kind of a crazy few days, but I will be back. If you do have questions on anything, of course, just leave a comment and I will be able to answer your question, hopefully. So have a great day, everyone, and I'll see you again very soon.